One of the stranger defenses, when you really sit back and think about it, to Florida domestic violence charges is consent. Think about it. If someone consents to be hit, then that's entirely lawful. If somebody says, take your best shot, and another person hits them in the stomach, well, it's kind of hard for that person to prevail if they're, for example, in this example, say in front of 10 people, they say that, the other person goes, are you sure? Yeah, I'm sure. Take your best shot. And, you know, maybe it's a 6'4" guy and a 5'2" woman, and, you know, the 6'4" guy doesn't know she's had karate, and so she pops him really good in the solar plexus, and he, you know, doesn't black out, but he doubles over in pain and then calls 911. That's not going to fly too well. Now, someone can still get arrested in a consent scenario because consent is a fact-specific defense. If you've been watching this series, you've noticed that I keep talking about fact and jury in the same sentence. Why? Because whenever you have a fact-based defense, you have a jury trial defense. Defenses are basically pre-trial or during trial, and you have to be very careful with them. So if you're going to use a consent defense, you want to make sure you're working with a lawyer who can find their way to the courthouse and knows what to do when they get there. If you have any questions about Florida criminal law or domestic violence specifically, feel free to give me a call.